defendant in the appeal, the Queen on the application of Roberts and the Commissioner of Police in Metropolis and another.
Mrs. Roberts was travelling on a number 149 bus in Tottenham. She had not paid her fare. She denied having any identification with her. The ticket inspector called the police. She continued to deny having any identification and kept a tight hold on her bag, even after the police officer required her to let it be searched. The officer was acting under the power to stop and search people for offensive weapons or dangerous instruments, which is contained in Section 60 of the Criminal Justice and Public Order Act 1994. Under that power, a senior police officer can authorise uniformed officers in a defined area to stop and search any person or vehicle for offensive weapons or dangerous instruments for a defined period of up to 24 hours, if the senior officer reasonably believes that the statutory grounds exist. In this case, there was a significant problem of gang-related violence in certain parts of the London borough of Haringey, and intelligence reports suggested that further incidents of serious violence were likely to take place that day, and that people would be travelling to Haringey carrying weapons which had been used in recent incidents of serious violence. Hence, Superintendent Barclay authorised the use of stop and search in certain parts of the borough for a period of 17 hours. An officer who acts under that power can stop anyone. He or she does not have to have reasonable grounds to suspect that the person stopped is indeed carrying an offensive weapon or dangerous instrument. It is what is known as a suspicionless power. Mrs. Roberts brought these proceedings to challenge the compatibility of the power with the right to respect for private life, which is protected by Article 8 of the European Convention on Human Rights. She accepted that its use in her case was a proportionate means of achieving a legitimate aim, namely the prevention of crime, and thus might be justified under Article 8(2). But she argued that the power itself did not meet the standard required for a provision to be law within the meaning of the Convention, because there were not sufficient safeguards against its being used in an arbitrary or discriminatory manner. She asked, therefore, for the court to make a declaration of incompatibility under the Human Rights Act 1998. Such a declaration does not affect the validity of the statutory provision in question or anything done under it. It is for Parliament to decide what, if anything, to do to make the law compatible. In this case, however, the Supreme Court holds that the power is not incompatible with the Convention rights. There are many safeguards against its use in an arbitrary or discriminatory manner, contained not only in Section 60 itself, but also in the provisions of the Police and Criminal Evidence Act 1984, the Code of Practice issued under that Act, and the standard operating procedures of the police force in question. Unlike a different power of stop and search, which was found incompatible by the European Court of Human Rights in the case of Gillen and the United Kingdom, this power is much more limited, both in time and place. The officer who grants the authorisation has to have a reasonable belief that the grounds exist, and he has to explain these in writing. The power exists to protect the public, including those members of the public who are most at risk from knife crime, from serious harm. The fact that anyone may be searched is an important part of its deterrent effect. The officer conducting the search has to act in a way which is compatible with the Convention rights of the individual who is stopped. He or she also has to explain and record in writing why he or she is doing so. In this case, the police officer had recorded, quote, "Area is a hotspot for gang violence and people in possession of knives. Subject kept holding tightly onto her bag and appeared nervous and as if trying to conceal something she didn't want police to find," end quote. These safeguards mean that it will be possible to judge whether any particular search was incompatible with the Convention rights of the person stopped. Hence, this court declines to make a declaration of incompatibility and the appeal is dismissed. The court will now adjourn.